Welcome to the explainer. Every promise, every handshake, every signature on a contract, it all comes with this big, unspoken question. What happens if someone just breaks their word? Today, we're going to dive into what the law says when a deal goes south, and more importantly, the power you actually have when that happens. Okay, so picture this. You've made a deal, right? Maybe you hired someone to build that perfect website, or you've got a contract to supply goods to a new client. Everything's looking great, and then, bam, they just don't deliver. Or worse, they refuse to pay. What do? It's super frustrating, for sure. But, and this is the good news, the law actually has a playbook for exactly this situation. The official term for this mess is a breach of contract. But here's the thing you really need to get. A breach doesn't just blow everything up automatically. Instead, it puts the person who is wronged, that's you in this story, at a really important crossroads. You've got a choice to make.
Right, so to really understand the choice you have at that crossroads, we've got to be crystal clear on what the law even counts as a broken deal. So let's start there.
It's pretty much as simple as it sounds. A breach of contract is just when one side either fails to do what they promised or they flat out refuse to do it. Bottom line, they broke the promise that was the whole point of the agreement in the first place. Now listen up, because this is the most important part. A breach doesn't hit some magic self-destruct button on the contract. No, what it does is it gives power to the other person, the one who's been let down. Suddenly, you're the one in the driver's seat. The power shifts, and you get to decide what happens next. And that brings us right back to that crossroads moment we were talking about. So the deal's been broken, you've been wronged, and now all the power is in your hands. So what are your options? Well, the law basically gives you two very different paths you can take. Think of it like this. You can go left or you can go right. Path 1 is deciding, you know what? This deal is dead to me. Path 2 is you digging in your heels and saying, nope, this deal is still on and you're going to finish it. And believe me, each path leads to a totally different destination. All right, let's talk about path number 1, walking away. This is the choice you make when you're just done. You've been let down, you've had enough, and you want to just cut your losses and move on. So if you go down this road, you're basically tearing up the contract and saying, we're done here. The fancy legal term is rescinding it. What this really means for you is you're off the hook. You don't have to do your part of the deal anymore. And the best part? You can immediately turn around and sue them for whatever losses you've suffered because they didn't hold up their end. Okay, but what if walking away isn't your best move? What if you still really want what was promised in the first place? Well, that leads us to the second path you can take. Choosing this path means you're not letting them off the hook that easily. You're signaling that, as far as you're concerned, this contract is still very much alive. You keep doing your part, and you demand that they do theirs. Now, if they still don't come through by the deadline, then you can sue them for the breach. You've basically kept the deal alive while reserving your right to fight later. This all brings up a really big question, right? Can any little mistake, any tiny slip-up give you the right to just walk away from a whole contract? Or does it have to be something serious? Let's take a look at how the courts figure this out. So the law has this really important distinction between a total breach and a partial one. A total breach is, well, total. It's a complete refusal to do the main thing you agreed on. It goes to the very heart of the contract, and yeah, that justifies ending the whole thing. A partial breach, on the other hand, is when they do some of what they promised, but not everything. That might not be enough to let you walk away. Let's look at a couple of real-world cases to see how this actually works. First up, let's check out the case of Sultan Chund versus Schiller. It all started with a pretty standard business deal for some linseed deliveries, but it got messy really fast over a few small disagreements. So here's the play-by-play. The seller delivers some of the goods, but the buyer holds back that final payment. Now, the buyer didn't say, I'm never paying you. They just said, hey, let's sort out these other minor issues with the packaging first, and then I'll give you the rest of the money. Well, the seller didn't like that one bit and stopped all future deliveries, claiming the buyer had completely breached the contract. So this is the million-dollar question for the court. Did the buyer's move, putting a condition on the final payment, count as a total breach? Was it a big enough deal to let the seller just cancel the whole contract? What do you think? And the court's answer was a big no. The reasoning here is absolutely key. The court said, look, the buyer didn't just say they'd never pay. They just attached a condition to that last payment. And because it wasn't a flat-out total refusal to perform, the seller totally overreacted by stopping all future deliveries. The court basically told them, nope, you got to keep the contract going. Okay, let's flip the script and look at another angle with our second case, West Bengal Financial Corp. Versus Glucose Series. This one's all about a loan agreement. Here's the situation. A lender gives a loan to a borrower. The contract also mentioned that the lender might grant a second loan down the road, but it was totally up to them. Well, what happens? The borrower completely fails to make the repayments on the first loan. So when they come back asking for that second loan, the lender, not surprisingly, says no. And then, get this, the borrower sues the lender, claiming they were the ones who breached the contract. I mean, this is a pretty wild legal question, isn't it? Could the borrower, who had already broken their own promise to repay the first loan, actually have a case that the lender breached the contract by not giving them even more money? Yeah, no surprise here, the court sided with the lender. It ruled that for it to be a real breach, it has to go to the essence, the very core of the contract. The lender had already done their main job by giving out the first loan. Refusing to give a second optional loan, especially after the borrower had already defaulted, was totally reasonable. You just can't sue someone for breaking a deal when you were the one who broke it first. Okay, so keeping those real-world examples in mind, let's bring it all home. Think of this next bit as your go-to toolkit for what happens after a breach. This chart really lays it all out. The person who breaks the contract, they're on the hook for any damages they caused. But the real story is the power that shifts to the person who didn't breach. You're not only free from your side of the bargain, but you get this whole legal toolkit. You can sue for money. That's damages. You can ask a court to force them to do what they promised. That's specific performance. Or you can even get a court order to stop them from doing something harmful. That's an injunction. It's a really powerful summary of your rights when a promise gets broken. At the end of the day, here's what it all boils down to. A contract isn't just a plan for when things go right. It's also your roadmap for when things go wrong. So the next time you're about to sign on the dotted line, don't just think about success. Ask yourself, if this all falls apart, which path am I going to take? Knowing that answer, well, that's how you make any deal with real confidence. Thanks for joining us on The Explainer.